Good morning, and to those here, and good morning to those who are watching us via live stream. Commissioner Solomon, would you lead us in the flag salute?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Madam Secretary, the public notice, please.
Adequate public notice has been given pursuant to the Open Publics Meeting Act. Notice have been posted at the board's office and having been delivered to the Department of State and to newspapers of broad circulation within the state.
Thank you. Roll call.
Commissioner Holden?
Yes.
Commissioner Solomon?
Here.
Commissioner Shivakula?
Yes.
Commissioner Gordon? President Fiorelisa?
Here. And our next meeting?
Our next meeting is scheduled for Friday, December 6th at 10 a.m., State House Annex Committee Room 11.
Okay, thank you. We will be having an executive session today, and we will be discussing an executive session, clean energy item D, regarding offshore wind solicitation. Clean energy item E, and miscellaneous item B. I anticipate that the executive session should last 40 minutes or so, and then we'll be out here. And we will be considering all of these items in executive session in open session. May I have a motion to go into executive session?
Second.
All those in favor? Thank you. We're in executive session. And
For items 8D, 8E, and 9B, the board is going into executive session pursuant to the contract negotiation exception to the Open Public Meetings Act, NJSA 10:4-12B7.
thank you. All right. Okay. We're back. We're back in open session. I just have a couple of remarks, and then I'll ask my colleagues if they have any opening remarks. As you know, we observed Veterans Day this past Monday, and I would like to take this moment to thank, on behalf of the BPU, all of the veterans who were willing to serve our country over the years. And some of them, unfortunately, had to make the ultimate sacrifice. But we all know that freedom is not free. It involves all of us protecting our freedom and enhancing our democracy. And we can never become complacent in thinking that it will always be here. It will always be here if we fight and are vigilant in making sure it is here and that we make sure that it becomes even more democratic as we move along. So I want to thank the veterans for your courage, your sacrifice, because you indeed are the true heroes. I would like to also recognize two of the utilities that we regulate. On Monday, as part of the New Jersey Veterans Day ceremony, Governor Murphy presented the, quote, "We value our veterans," end quote, award to corporate and municipal honorees, which included PSE&G and Suez North America. Obviously, it's vital, as I said before, that we support our veterans, and I would just like to commend PSE&G and Suez for their continued commitment to our veterans and for recognizing them in such a grand fashion. The Board of Public Utilities has gained another staff member. Hannah Roman comes to us from ICF and has a background in energy and sustainability. Is Hannah here? There she is. Welcome. And we're excited to have her join our energy efficiency team as we continue in partnership with our utilities to embark on a transition into the future. Anyone else have any opening comments? Yes, sir.
Now, we'll be celebrating Thanksgiving soon. I just wanted to, as you already thanked the veterans, that's very important. Also, I want to thank the ratepayers because as we thank the ratepayers, we need to think about from the beginning what the rates were for electricity, natural gas, water, and all that. And towards the end of the year, different programs we have voted for, supported, and all those things, the cumulative aspect of all those programs. At the end of the year, if we have those numbers, we can say, look, this is, so that way it gives you a new starting point for the next year. Because I think a lot of times drips and drabs and little programs come here, but the cumulative impact of those rate increases are going to be felt by the ratepayer. So we need to make sure we are prudent, and we want to make sure that we have the data, correct data available to us. So thank you.
Thank you. And thanks for bringing up Thanksgiving. I forgot that we don't have a meeting before Thanksgiving, so I'd like to wish everybody a happy Thanksgiving. I'm sure we all have many things to be thankful for, and our veterans are certainly among the top that we should be thankful for. Okay, anyone else? Madam Secretary, the consent agenda, please.
On the following consent agenda items, 1A, 2A, 2B, 3A, 4A, 5A, 5B, 7A, 7B, 7C, and 9A.
Roll call.
Commissioner Holden?
Yes.
Commissioner Solomon?
Yes.
Commissioner Shivakula?
Yes.
Commissioner Gordon? President Fiorlisa?
Yes. Any others? That's it? Okay. We'll now proceed with the regular agenda. Nothing under audits to be considered. That brings us to you, Stacy. Energy.
Good morning, Commissioners. Agenda item 2A relates to a February 2017 petition filed by Donald McKay seeking monetary reimbursement from JCP&L for a project at his residence. On November 14, 2017, JCP&L submitted its answer to the petition, and the matter was transmitted to the OAL on February 2, 2018, and assigned to Administrative Law Judge Irene Jones. On April 11th, a hearing was held before ALJ Jones where the petitioner, his wife, and a JCP&L engineer testified. Post-hearing briefs were filed after the hearing. On August 29th of 2019, ALJ Jones issued an initial decision dismissing the petition, finding that the petitioner did not meet his burden of proof. Staff recommends the board approve the initial decision without modification.
So moved.
Comments? Questions? Roll call.
On the motion to approve staff's recommendation, Commissioner Holden?
Yes.
Commissioner Solomon? Yes. Commissioner Chivukula?
Yes.
Commissioner Gordon? President Fiordaliso?
Yes. 2B relates to Atlantic City Electric's infrastructure investment program.
Correct. On April 18th of this year, the board issued an order approving a stipulation in ACE's infrastructure investment program. The order provided ACE with approval to invest approximately $96 million in capital investments with accelerated recovery. A specific tenet of the stipulation and the April order set forth a schedule for roll-ins related to investments. The first roll-in was to be filed on November 1st of 2019. On October 25th, ACE filed a letter requesting a modification of the stipulation that was approved in the April order. Specifically, ACE requested to modify the roll-in schedule to allow the first filing to be made on May 1st of 2020. In the letter, ACE indicated that the company concluded that although progress is being made on the projects, it was unlikely that $9.6 million would be placed into service to meet the filing threshold for the initial filing. No objection to the request was received by any party. Staff recommends the board approve the modification to the stipulation and that the board direct ACE to retain an independent monitor for the program by March 1st of 2020.
So moved.
Questions? Comments? Roll call.
On the motion to approve staff's recommendation, Commissioner Holden?
Yes.
Commissioner Solomon? Yes. Commissioner Chivukula?
Yes.
Commissioner Gordon? Yes. President Fiordaliso?
Yes. 2C, E-Town base tariff.
Correct. On April 18th, Elizabethtown filed a petition seeking an increase in its operating revenues of approximately $65.03 million. Elizabethtown's petition also requested a return on equity of 10.4% and sought authority to establish a regulatory asset in which the incremental cost associated with transmission integrity management program incurred between rate cases would be tracked and deferred for later review and recovery. This matter was transmitted to the Office of Administrative Law and assigned to ALJ Jones. Through the course of the proceeding, Elizabethtown updated its request to include actual information through the end of the test year, which reflected an updated revenue requirement of approximately $65.5 million. Throughout the course of the proceeding, the parties held numerous discovery and settlement conferences and subsequently executed a stipulation, which ALJ Jones approved on October 30th. Some key features of the stipulation are a settlement revenue requirement of $34 million, an ROE of 9.6%, with a capital structure of 51.5% equity and 48.5% debt. Additionally, there will be an amortization of several debits and credits and the creation of the regulatory asset related to the Transmission Integrity Management Program costs. Stipulation also reflects a change in the residential monthly customer charge to $10. As a result of the stipulation, a typical residential customer using 100 therms in a winter month will experience an increase in their monthly bill of $9.38. Staff recommends the board issue an order approving the initial decision and stipulation for services rendered on and after November 15th. Staff also recommends the board direct Elizabethtown to file revised tariffs by November 15th.
So moved.
Questions? Comments? Roll call.
On the motion to approve staff's recommendation, Commissioner Holden?
Yes.
Commissioner Solomon? Yes. Commissioner Chivukula?
Yes.
Commissioner Gordon? Yes. President Fiordaliso?
Yes. 2D, New Jersey Natural Gas's request for deferred accounting authority for costs related to IT systems.
Correct, and there's also a base rate case. They're both consolidated.
Yes.
So in October 2018, New Jersey Natural filed a petition seeking deferred accounting treatment for costs associated with upgrades to the company's information technology systems. New Jersey Natural requested approval to defer on its books actual costs incurred that would be reviewed in a future base rate case. On March 29th, New Jersey Natural filed a petition for approval of an increase in its operating revenues of approximately $128.2 million. The company also sought approval to implement new depreciation rates and a return on equity of 10.875%. Additionally, New Jersey Natural sought approval to establish a Phase 2 of the proceeding to address the cost recovery of the company's Southern Reliability Link interstate gas transmission project, which commenced construction in November of 2018 and was anticipated to be in service in 2020. Subsequently, New Jersey Natural filed a motion to consolidate both petitions, and the matters were transmitted to the Office of Administrative Law and assigned to ALJ Gertzman. Through the course of the proceeding, New Jersey Natural updated its request to include actual information through the end of the test year, which reflected an updated revenue requirement of approximately $134.3 million. Following discovery and settlement conferences, the parties executed a stipulation which was approved by ALJ Gertzman on October 30th. Some key features of the stipulation are a settlement revenue requirement of $62.2 million, an ROE of 9.6% with a capital structure of 54% equity and 46% debt, no deferred accounting related to the IT project, no Phase 2 related to the SRL project. The stipulation also reflects a change in the residential customer monthly charge to $10. As a result of the stipulation, a typical residential customer using 100 therms in a winter month will see an increase in their monthly bill of $10.04. Staff recommends that the board issue an order approving the initial decision and stipulation for service rendered on and after November 15th. Staff further recommends the board direct New Jersey Natural to file revised tariffs by November 15th.
So moved.
Questions? Comments? Roll call.
On the motion to approve staff's recommendation, Commissioner Holden,
Yes.
Commissioner Solomon,
Yes.
Commissioner Chivukula,
Yes.
Commissioner Gordon, President Fiordaliso.
Yes. Stace?
On June 27th, Public Service filed a petition seeking approval for gas base rate changes to provide for cost recovery associated with certain capitalized investments related to the second phase of its gas system modernization program. The company sought approval to recover a revenue requirement of $19.7 million. Throughout the course of the proceeding, the company updated its schedules, which decreased the proposed revenue requirement to $17.3 million. On October 24th, the parties executed a stipulation that would allow the company to recover the updated revenue requirement. As a result of the stipulation, a typical residential heating customer would see an increase in their annual bill of $10.16. Staff recommends that the board issue an order adopting the stipulation and directing PS to file revised tariffs by December 1st.
So moved.
Comments? Questions? Roll call.
On the motion to approve staff's recommendation, Commissioner Holden,
Yes.
Commissioner Solomon,
Yes.
Commissioner Chivukula,
Yes.
Commissioner Gordon, President Fiordaliso.
Yes. 2F, a BGS item.
Correct. I apologize. This presentation's a little longer than the other ones. There were a lot of issues in this proceeding. So this agenda item is a
I'm sorry, what did you apologize for?
for being a longer presentation.
Oh, we like to hear you talk.
It was a long memo in order. This item is a recommendation for securing electric power supplies for non-shopping BGS customers for the period beginning June 1st of 2020. Staff's recommendation is to allow the electric distribution companies to conduct 2 descending clock auctions similar to those approved by the board for the past 18 years. The auctions would be conducted in February of 2020 and would secure full electric requirements for hourly price service for the largest electric customers and the full electric requirements for smaller commercial and residential customers. By way of background, the board issued an order on April 18th, opening a proceeding to determine how to procure the remaining 1/3 of the state's RSCP and the annual CIEP requirements for the period beginning June 1 of 2020. The board directed the EDCs, as well as any other interested party, to file proposals consistent with its order by July 1st of 2019. A joint filing was received from the EDCs. Initial comments on the proposal were filed around September 4th of 2019. Public hearings were held in each electric company service territory in September, and a legislative type hearing was held on September 19th. The EDCs filed a supplemental proposal on October 8th, and final comments were submitted by parties on October 25th. Based on the experience of previous auctions and having considered the record, staff continues to believe that the staggered 3-year rolling procurement period currently in use for RSCP is appropriate. Historically, auctions have occurred over a period of 3 or more days, with the CIP auction starting on a Friday and the RSCP auction starting the next Monday. The EDCs have proposed to change the schedule so that the two separate auctions would start at the same time. Additionally, the EDCs proposed to move the Part 1 application date to January 9th of 2020 to avoid the holidays. Rate Council has opposed both changes. Staff is not convinced that the EDC's proposal to conduct simultaneous auctions would improve the auction process. Potential bidders have not previously expressed concern, and none expressed concern in this proceeding. The current process allows bidders to focus on one auction at a time, with the exception of a small window of time where the two auctions overlap. It also allows the auction manager and board advisor time to review round-by-round results and review and confirm key decisions. Staff believes the current process, overlapping the initial rounds of one auction with the closing rounds of the second, ensures that reviews for both auctions can be conducted properly. The EDCs have also not been able to quantify any potential savings that the proposed simultaneous auctions would produce. Moving the timing of the Part 1 application process also would have an impact on the trial auction. Under the EDC's proposal, assuming the real auction was to start on Friday, the trial auction would be the day before the actual auction. Should something problematic occur in the trial auction, it could prove difficult to remedy before the actual auctions. Accordingly, staff recommends that the board reject the EDC's request to modify the schedule for the BGS auctions. In the current filing, the EDCs proposed modification to the terms of the supplier master agreements, which would require each supplier to provide renewable energy certificates and solar renewable energy certificates after each of the first 3 quarters of the energy year, or post collateral for the value associated with the RECs and SRECs. Previously, these have been provided to the EDCs at the end of the energy year. According to the companies, the proposed amendments were aimed at mitigating the risk of the RPS compliance by the EDCs in the event that a supplier defaulted on its obligation. As noted by both Rate Council and the EDCs, in the previous 5 years, there have not been any defaults by BGS suppliers. The EDCs have also not been able to demonstrate that their proposed change would not have an adverse impact on potential suppliers. Staff recommends that the board reject the EDC's request. TransAlta, a supplier, recommended that the supplier master agreements, specifically Article 6, allow suppliers with a credit rating below a certain amount be able to use unsecured credit subject to specified limits instead of the current proposed limit of 0. The EDCs have opposed the request, stating that the provisions of the SMAs provide essential protections for BGS customers. Staff agrees with the companies and does not see a need to modify the unsecured credit limits set forth in the supplier master agreements. Staff recommends that the board reject. TransAlta recommended that the bidding process include a step to allow a bidder with a foreign guarantor to discuss the required draft legal opinion, as it would provide bidding process efficiency. The EDCs have agreed that this could enhance the current application process, and staff believes that the EDC's proposal is reasonable and should be adopted. Several suppliers have expressed concerns related to the delays in reimbursement to BGS suppliers of increased transmission costs assessed by PJM, which suppliers believe hurt the competitiveness of the BGS auction by forcing suppliers to shoulder significant additional costs for undefined periods of time. Several suppliers have proposed a change to the treatment of these charges as set forth in Section 15.9 of the supplier master agreements, to either require the EDCs to pay the transmission costs directly to PJM without any pass-through to suppliers, as is done in other jurisdictions, or allow the EDCs, subject to board approval, to reimburse suppliers at the time PJM bills those increased charges. Suppliers believe that if these transmission costs continue to be passed through to suppliers, and if the EDCs continue to withhold the money from suppliers, it is reasonable to expect that auction participants will add greater risk premiums to their bids. Alternatively, some suppliers have requested the board remove the supplier's obligation for the portion of the tax associated with pending cases at FERC, specific to the Con Ed Wheel and HTP and Linden VFT transmission charges. Rate Counsel urged the board to maintain the safeguards within Section 15.9 and reject the request to pass through payment of non-final transmission rate increases. The EDCs have acknowledged the concerns expressed by the parties and indicated that they're supportive of working with the board and stakeholders to identify opportunities to remedy the issue, but believe it is inappropriate to make changes in this proceeding. The EDCs have suggested that the board explore other mechanisms to address the payment lag concerns. Staff believes the concerns of the current construct provides a balance between the protection of ratepayers and the concerns of suppliers regarding risk, while allowing the board discretion on a case-by-case basis. Staff recommends the board reject the proposed modifications to Section 15.9 at this time. However, staff is also concerned about the continued delays at FERC and the growing backlog of pending matters, and believes this issue should be addressed in a future proceeding. Staff recommends that the board direct staff to work with the parties prior to the filing of the 2021 BGS auction proposals in an attempt to find a resolution to the issue. With respect to certain parties' requests to modify the board's orders related to the Con Ed Wheel and HTP and Linden VFT payments, at this time staff recommends that those requests be denied. The purpose of the instant proceeding is to determine the 2020 BGS auction process. Any requests related to previous board orders should be filed within those dockets. In its comments, the Independent Energy Producers of New Jersey requested the board make a decision as soon as possible regarding its solar transition program and clearly state the percentage obligation of suppliers in advance of the 2020 auction. The EDCs have supported this request for clarification. Staff recognizes the need for clarification regarding the issue. However, the solar transition program is still under development, and until the board makes a decision, guidance cannot be given to suppliers. Staff recommends that at the time a decision is made regarding the solar transition program, guidance be given to potential suppliers regarding the solar RPS requirements. Additionally, in its comments, IEP&J claimed that a disparity currently exists in the auction format in which RPS obligations for BGS suppliers are calculated at the wholesale meter, while TPS obligations are calculated at the retail meter. IEP&J asserted that the board should provide clear direction that the related RPS obligations should be based at the retail meter. The EDCs and Rate Counsel noted that the BGS and TPS suppliers operate under different requirements, wherein BGS suppliers are wholesale providers to the EDCs with an obligation to be the default provider and not retail sellers to end-use customers. Staff believes at this point, given the different supplier relationships and access to data, the current format is appropriate and recommends that no changes be made in the RPS obligations. On July 20th of 2019, FERC ordered PJM not to hold the capacity auction scheduled to begin on August 14th of 2019, which would have procured the capacity for the 2022 to 2023 delivery year. All parties recognize that there is uncertainty regarding the capacity auction, which may lead to risk premiums. On October 8th, the EDC submitted a supplemental proposal related to the capacity price for energy year 23. The supplemental proposal proposed a capacity proxy price for each EDC, a supplement to the RSCP Supplier Master Agreement to allow payment to or from suppliers of the difference between the actual price and the proxy price, and a modification to the rate design methodology in each company-specific addendum to allow for the eventual calculation of the change in auction prices. In final comments, several suppliers supported the EDC's supplemental proposal, including the capacity proxy price, as a reasonable way to address the timing problem resulting from the postponement of the BRA. In its final comments, IEP&J urged the board to implement additional measures to mitigate this risk and specify when and how suppliers would be paid. Additionally, IEP&J asserted that the board should address new volume risk that would occur since the quantity of capacity that PJM is procuring will not be known until energy year 2023 BRA occurs. Rate Council submitted comments on the development of the proxy price, the rate design component to the true-up differences, and the new SMA language that the EDCs had proposed. Rate Council asserted that BRA results, as opposed to incremental auction prices used by the EDCs, should be used as the starting price, and also had a lower factor used to develop the proxy price. Rate Council also recommended that the BGS price to compare following the 2020 auction be modified. Rate Council further expressed concerns regarding the rate design component of the supplemental proposal and proposed an alternative billing mechanism. Rate Council opposed Section 9.1L of the proposed SMA language, believing it is overly broad and vague, since any additional charge relating to changes in the capacity market could be included without allowing for a review by the board. Staff acknowledges and agrees that it is unknown when the capacity price for the 2022-2023 delivery year will be set, and bidders must have some set price for capacity in order to include in their bids. Staff recognizes the difficulty in setting a proxy price, as the RPM auctions have traditionally produced volatile results. Since staff cannot know the upcoming capacity auction price, and since the EDC's numbers more clearly reflect recent prices, staff recommends using the proposed EDC numbers as the proxy price. While staff recognizes the concerns related to price to compare raised by Rate Council, adopting Rate Council's recommendation may actually confuse the price to compare calculation, and staff recommends that there be no change in the way the EDCs calculate the price to compare. Staff does agree with Rate Council that the proposed language in Section 9.1L is overly broad and recommends that such charges be filed for board approval so the board can consider their nature and impact prior to authorizing collection. With the modifications and additions suggested, staff recommends that the board approve the same basic descending clock auction process, auction rules, board approval process, and supplier master agreements that have been previously employed over the past few years. Staff also recommends the board require each of the EDCs to file an amended compliance filing by November 29th, and authorize staff to review the filings and request that the board secretary issue a compliance letter if the filings are found to be compliant.
So moved.
Now you can apologize.
I did it up front.
Questions? Yes.
Yeah, Stacy, in summary, basically, we held the legislative type hearing, and there were some recommendations that were made, and we are not accepting the recommendations of the EDCs and IEPs and all that stuff, right? That's one thing.
Yeah, so
we'll continue to have a descending clock type of auction, which is, and we will continue to have an auction on a Friday followed by a Monday. And so basically, there are not many changes, and we are awaiting because of the FERC rules, we are awaiting what we're going to do with the capacity auction part.
yeah, I could have made this presentation a lot shorter if you would have just.
There's four things, right?
Yes, correct.
That's the.
Maybe next time the commission can write it for you.
I'm happy where I am.
Any other comments?
That's it. Thank you.
Questions? Roll call.
On the motion to approve staff's recommendation, Commissioner Holden?
Yes.
Commissioner Solomon?
Yes.
Commissioner Chivukula?
Yes.
Commissioner Gordon? President Farrelly?
Yes. Thank you, Stacy. That brings us down to 2G, FERC Fast Start Compliance Filing. Ms. Holland.
Good morning, Commissioners.
Now you are.
Am I on?
Yes, ma'am.
All right, you can hear me now? All right, well, good morning again, Commissioners. Before I get started on item 2G, I just want to acknowledge my responsibility for more than half of that presentation because it pertained to transmission costs and the uncertainty at FERC regarding the capacity market. And for that, I'm equally sorry.
Well, it sounded like a lawyer wrote it.
I didn't write it, but yeah, unfortunately, I'll likely have some lengthy presentations regarding the capacity market. On item 2G, Staff is asking the board to ratify an answer that staff filed on behalf of the board in late October. The answer is an extension of the board's prior protest in this compliance filing proceeding. If you recall, in our prior protest, the board identified several deficiencies with the compliance filing filed by PJM at the Federal Energy Regulatory Commission. Among those deficiencies was a failure to adequately address some market power concerns that had been identified by FERC itself in the order. In response to the board's protest, as well as other protests, including a protest of the independent market monitor, PJM references an informational filing that it submitted to FERC. As further evidence of, it's addressing this concern. Staff has reviewed that informational filing as well as PJM's answer to the protests, and consistent with the board's initial protest, finds that really FERC's concerns about market power are not being adequately addressed. In addition, the independent market monitor has filed answers to both the informational filing proceeding, identifying that the market power concerns are real and have not been adequately addressed. For that reason, staff, on behalf of the board, identifies the deficiency, but also asks that FERC establish a path forward for the market monitor and PJM to work together to address this issue. And we ask that FERC does so without undue delay to this proceeding, because we recognize that this proceeding has been long going, and we do not want to further delay the implementation of fast start pricing. For that reason, staff is asking that the board ratify the answer that we made in this proceeding.
So moved.
Questions? Comments? Yes.
Yeah. In other words, it's a victory lap, right? We are trying to at least acknowledge that there's some market power issues are there, and not just saying that it's informational hearing, but also got to go back to the drawing board, get all that information.
Yes.
Thank you.
Any other questions? Comments? We have to continue to be on the heels of FERC to keep them moving, even though they have been terribly ineffective. But we're doing our part, and we ask all of our colleagues in neighboring states to do their part too. So, roll call.
On the motion to approve staff's recommendation, Commissioner Holden,
Yes.
Commissioner Solomon, Commissioner Chivukula,
Yes.
Commissioner Gordon, President Fiorelliso.
Yes. Another FERC item, 2H, regarding critical infrastructure protection reliability standards.
Yes, so this item is far less contentious. What this is a joint staff white paper that was produced by staff from the Federal Energy Regulatory Commission, as well as the North American Electric Reliability Corporation, regarding how notices of penalty are handled under the Freedom of Information Act. FERC in particular has been inundated with a number of FOIA requests, the Freedom of Information Act, and they were struggling with how to balance the desire for transparency with protection of critical energy infrastructure information. The outcome of that was this white paper where staff of these two agencies made several recommendations. Most notably is that going forward, staff is recommending that for notices of penalty for these violations, there would be a public cover sheet provided that identifies the name of the violator, the standard that was violated, and the penalty, and then appended to that document would be all of the confidential critical energy infrastructure information. Staff from my division worked with reliability and security on this matter, and upon review, identified that this is a reasonable balance that FERC staff is striking, or the joint staffs are striking. However, it was identified that there's the potential concern that information may not be made accessible to state commissions, in particular when it relates to cybersecurity, because some of the information attached to the public cover sheet concerns mitigation. And we wanted to ensure that the board has access to all of that mitigation information. So we just asked that the joint staffs clarify that the state commissions that have the ability to protect that confidential information, as the board does, can have access to that information so that we can effectively do the work on behalf of the board. Therefore, staff is asking that the board ratify our comments in this proceeding.
So moved.
Questions? Comments? Roll call.
On the motion to approve staff's recommendation, Commissioner Holden,
Yes.
Commissioner Solomon,
Yes.
Commissioner Chivukula,
Yes.
Commissioner Gordon, President Fiorelliso.
Yes. 2I, regarding PJM tariff filing.
Yes, thank you. Moving right along. Staff, on behalf of the board, filed comments in support of PJM's tariff filing in this instance. Thanks for that, Commissioner Holden. So yes, we did, in fact, on behalf of the board, file comments in support of this filing. Most notably because the board has previously been very vocal on this issue, and so therefore we wanted to continue the board's advocacy in this realm, including many statements of current and former commissioners, both comments at these board meetings and in technical conferences and hearings at FERC. Most noticeably, the PJM proposed language requires them to consider, as part of the competitive process that they have, a comparative analysis of cost commitment proposals. This is kind of an extension of the cost cap discussions that have previously been held. In addition, PJM is going to be doing an analysis of cost effectiveness of the different competitive bids that were submitted. Different protests were filed by the incumbent transmission owners, but PJM has also filed an answer in response to that in the pending docket. So therefore, staff is asking that the board ratify our comments in support of the tariff filing.
So moved.
Questions? Comments? Roll call.
On the motion to approve staff's recommendation, Commissioner Holden,
Yes.
Commissioner Solomon, Commissioner Chivukula,
Yes.
Commissioner Gordon, President Fiorelliso.
Yes. 2J, regarding FERC again and the Texas Eastern Transmission rate case.
Yes. So it's important to distinguish this from some of the other items, the other FERC items on the agenda, is that we are not asking the board to ratify anything in this docket. What this matter is a litigated rate case before the Federal Energy Regulatory Commission. It was initiated by Texas Eastern, which is the interstate gas pipeline company that sells and at wholesale to many of our gas companies here in the state. Texas Eastern had not been into its regulator for a number of years, a very significant number of years, and had requested a sizable rate increase. This was then litigated and put into settlement negotiations at FERC that were overseen by an administrative law judge at FERC. Several parties actively engaged in this proceeding, and both the Division of Law and staff monitored this proceeding throughout the process. Those parties ultimately reached a negotiated settlement that was filed with FERC late in October. I believe it was shortly after our agenda meeting, if not the day of our agenda meeting. So approximately October 25th. That settlement document identifies a rate increase that is less than what had been proposed by Texas Eastern initially. And I won't go through all of the details of the settlement, but most notably attached to that is a listing of the supporting and non-opposing parties, many of which, of course, are distribution companies here in the state. Having monitored this proceeding, board staff has no basis to recommend contesting this settlement. But board staff similarly does not recommend supporting the settlement in an affirmative way. historically, the board has identified itself on these types of settlements as a non-opposing party. However, this settlement has already been filed, so it is already public, and there is no opportunity now to identify ourselves on that attached list as a non-opposing party. That's why staff is actually recommending no further action in this proceeding at this time, which is the equivalent of not opposing the settlement. So staff's recommendation is no further action.
So moved.
Questions? Comments? Roll call.
On the motion to approve staff's recommendation, Commissioner Holden?
Yes.
Commissioner Solomon?
Yes.
Commissioner Chivukula?
Yes.
Commissioner Gordon? President Fiordaliso?
Yes. 2K, another FERC item, and this involves transmission owner and border rate case adjustment.
Yes. So this was on your agenda back in October, and we are kind of building off of that prior protest. So again, in October, the board ratified a protest in this proceeding. Most notably, in that initial protest, the board identified concerns about the adverse rate impacts that have been suffered by PSE&G rate payers as a result of some of the New York SEAM litigation that we have talked about at length at these board meetings. And in that protest, the board also urged FERC to address all of those SEAM concerns and this border rate issue holistically in further proceedings. Subsequent to the board's protest, the PJM transmission owners submitted an answer to that protest and to other protests. And in that answer, they specifically identified certain arguments that they took issue with, and in particular, the board's position. And they made certain misrepresentations of the board's position. Therefore, staff on behalf of the board filed a subsequent answer to clarify the board's position on some of these aspects, including the fact that the board is aware that the border rate is more than just the New York SEAM. It's just that the New York SEAM is a really significant aspect of that border between PJM and other regions. And we clarified again the board's interest in having this matter addressed holistically in further proceedings. Subsequent to filing that answer, FERC has taken action in this docket, and they identified the need for a evidentiary hearing and scheduled prior to that evidentiary hearing settlement procedures before an administrative law judge. That actually took place earlier this month, shortly before this agenda meeting. So I wanted to notify the commissioners of that change in the status of this case. However, what's pending before you today for a vote is ratification of staff's answer on behalf of the board.
So moved. Second.
Questions?
Cynthia, one question. I think the PJM transmission owners have accepted that there's a revenue for the border rate service is about 25% of the overall cost.
What they identified was that the transactions along the New York SEAM are only about 25% of the overall border rate and the revenue collected from the entire border of PJM. So that would be with MISO and Tennessee Valley Authority, et cetera.
It's a pretty significant number.
I would agree.
Cynthia, do we see the possibility, at least, of some relief regarding the SEAM problem with New York? I mean, I love New York, but I love New Jersey more. So I'm tired of New Jersey ratepayers subsidizing another ISO and so on. Do we see with these actions that you presented here a possibility that the ratepayer may get some relief on this?
Well, I can't predict the outcome at FERC.
I'm not asking you to predict.
But I will say that staff are willing to attend these settlement conferences and advocate to the best of our ability on behalf of the state of New Jersey and this board in particular.
And this is a battle. I appreciate that. Thank you. This is a battle that has been going on for a very long time. And I guess I'm feeling a little good about it, that there's maybe some movement and so on. And this is an issue that really created a lot of problems, I think, within the entire PJM footprint and so on. So it's something that we will continue, again, to be on the heels of FERC and to ensure the fact that the New Jersey ratepayer and the state of New Jersey in general is represented well, because it's something that has to be rectified. So I thank you for that. Thank you for your presentation. Are you done? Oh. Do we need to? All right. Why don't you call the roll call?
On the motion to approve staff's recommendation, Commissioner Holden?
Yes.
Commissioner Solomon?
Yes.
Commissioner Chivukula?
Yes.
Commissioner Gordon? President Fiorello?
Yes. Yes, thank you, Cynthia. Ben, you up next? Regarding PSE&G issuing long-term debt?
Good morning, Commissioners, Mr. President.
Sir?
As a prelude to two financing petitions that are before you today and several more that are expected before the end of the calendar year, I'd like to emphasize that current interest rates on medium and long-term borrowing are back to historically low levels. So this is a time when utility companies should take advantage, and many are taking advantage, of the timing opportunity to raise significant capital at very low rates. Since most of the capital raised this way is through medium and long-term instruments, there's substantial benefit to the company and its customers, as this historically low-rate borrowing will keep the average cost of capital that much lower for many years to come. And item 2L.
And that's good.
Is very good. Item 2L, excuse me.
Happens to me all the time.
This is the petition for Public Service Electric and Gas Company for authority to sell and issue up to $3.2 billion of long-term debt obligations through December 31st of 2021. The proposed long-term debt to be issued will range from 1 year to 40-year maturities and may be secured or unsecured depending on market conditions. The company states that the debt obligations will be used to provide capital to fund physical plant and facilities, construction and maintenance of existing infrastructure and new infrastructure, acquisition opportunities, and other general corporate purposes. The funds will also be used to refund $693,380,000 of its medium-term notes maturing in 2020 and 2021, and the refunding, redemption, and purchase or defeasance of additional outstanding long-term debt securities. Public Service Electric and Gas has a long-term issuer credit rating of BBB+ from Standard & Poor's and a long-term issuer rating of A2 from Moody's, which will allow it to raise capital on attractive terms from both public and private financial markets. The Rate Council has reviewed the petition and is not opposed to approval, and the Office of the Economist recommends approval of this petition.
So moved. Second.
Questions? Comments? Roll call.
On the motion to approve staff's recommendation, Commissioner Holden?
Yes.
Commissioner Solomon?
Yes.
Commissioner Chivukula?
Yes.
Commissioner Gordon? President Fiorello?
Yes. Before you go on to the next one, Ben, because the next one is yours too, right?
No, the next one for me will be water. There's one more.
Oh, okay. All right. As you all know, I introduced at the last meeting the new leadership in our Attorney General's office that services the BPU and so on. And we've also, in addition to new leadership, we've also gotten many new Deputy Attorneys General. And we have one up here. Would you like to introduce yourself?
Yes, thank you, Mr. President. Michael Beck, Deputy Attorney General. It's a pleasure to appear before the board in the couple of weeks that I've been working thus far. I'm very impressed with the diligence of the staff and the complexity of matters that appear before this board. By way of very quick background, I've been practicing attorney for 17 years, so
Oh.
while I'm still
Well, thank you and welcome. Heather, you're the next one.
I'm going to have the shortest presentation of them all.
Well, you're going to make up for Stacy then.
I helped on that one.
It's all on average.
We all work, and that Stacy deserves all the credit.
So that's 2M we're looking at.
Yes, we are, sir. Good morning, Mr. President and fellow commissioners. On October 7th, 2019, Navigate Consulting was retained by the board to conduct a cost-benefit analysis of Rockland Electric Company's Advanced Metering Infrastructure Program. This is referred to as the Capstone Report. On November 6, 2019, Navigate filed the Capstone Report with the board. This report is more specifically entitled Independent Review of RICO's AMI Business Case and Recommendations for New Jersey Board of Public Utilities. Staff is recommending that the Capstone Report be accepted for filing purposes and be made available to the public via the board's website, and additionally, staff is recommending that the Capstone Report be entered into the record and subject to discovery. So moved. Second.
Comments? Questions? Roll call.
On the motion to approve staff's recommendation, Commissioner Holden,
Yes.
Commissioner Solomon, Commissioner Chivukula,
Yes.
Commissioner Gordon, President Fiorelliso.
Yes. Thank you, Heather. Thank you, ladies. Thank you, Ben. And we now go to cable television, 3A, regarding Altice.
That would be me.
Okay.
Lawanda's not feeling well, so
Okay.
she asked me to do it. This is the matter of the alleged failure of Altice USA to comply with certain provisions of the New Jersey Cable Television Act and the New Jersey Administrative Code, the cease and desist order. A little bit of background: in 2011, Cablevision at the time, the predecessor to Altice, filed a motion for relief from certain sections of the board's regulations regarding billing for cable television company. That was approved. It was similar to or identical to a request that had been made by Verizon, also a cable company supplying file service in New Jersey. In 2015, Cablevision filed a petition seeking approval of a merger with Altice, and in May of 2016, the board approved a stipulation of settlement wherein Altice agreed that it would abide by all applicable customer service standards, performance standards, and service metrics delineated under NJAC Title 14, including but not limited to Chapter 3, 10 and 18, and NJSA 48:5A, including but not limited to requirements related to billing practices and termination, which essentially was consistent with the prior approval for Cablevision. At the time of the original approval of Cablevision, Cablevision's request in 2011, and subsequent to the takeover or merger with Altice, the company began and continued to prorate customer bills in the event that a customer left after paying their bill but left some portion of that month. The company would refund the remaining amount of money, the proration. Would refund the remaining amount of money for the proration of the month. So they would basically return the unused, if you will, the unused portion of it. In October of 2016, the company discontinued the proration practice without providing any notice to either staff or to the board. Following that change in policy, the board received over 100 complaints from consumers seeking refunds from the company who were billed for services that they did not receive following discontinuance of service prior to the end of the month. After reviewing the complaints, Staff recommended and the board in December of 2018 approved the issuance of an order to show cause, requiring Altice to show cause before the board why it should not be ordered to cease and desist immediately in its failure to properly prorate customer bills, why the board should not find Altice's actions for failure to properly prorate from the period October 2016 to the present to constitute a violation of the rule, relief order, and the merger order, and why a monetary penalty for failure to comply with the rule, relief order, and merger order should not be assessed, and why the board should not order Altice to issue refunds to all customers. Altice responded, the company was properly served, and Altice filed an answer on January 31st of 2019. Rate Counsel filed a response to Altice's answer in March, and Altice filed their reply to Rate Counsel in April. Altice's position is essentially that the waiver that they were granted was unconditional and that they are not required to prorate, notwithstanding the fact that they prorated from 2011 through 2016. Staff has had a number of meetings with the company. We've discussed it at length. Staff is of the opinion that they were required to prorate based on their application and their submissions to the board. Rate Counsel concurs in that relief. At this time, staff is recommending the following, that the board take the following actions. That the board make a determination that pursuant to the 2011 rule relief order and the subsequent merger order, Altice be required to prorate customer bills, and that its failure to do so violates the rules, the board's rules, the relief order, and the merger order, that they are in violation and therefore must immediately cease and desist from the failure to comply with the existing rules, that Altice would be required to conduct an audit of its customer billing records from the date it ceased proration of customer bills, and report to the board the names and account numbers of customers that were improperly billed, the amounts that they were improperly billed, that they must refund to customers within 60 days from the date of the order, the appropriate amount to account for the billings taken by the company since 2016. And finally, that they should remit, Altice should remit a one-time non-recoverable contribution of $10,000 towards the Altice Advantage Internet program to provide low-cost internet service to New Jersey customers who are eligible for or participate in the National School Lunch Program, or eligible for or receive Supplemental Security Income, SSI, and are 65 years of age or older, or a veteran, and receive state or federal public assistance. That's the board, that's the staff's recommendations.
So moved. Second.
Questions?
Basically, we are trying to make sure that they follow the law.
Yes.
That's the rule of relief order. They're trying to say the board doesn't have jurisdiction, and we do have jurisdiction.
Yes, essentially, what they're saying is that the board granted them a waiver that's unconditional, and the staff position, and I think based on the board's orders to cease and desist, is that that was not, certainly not the intention. I would also point out that to the extent there was a waiver granted, the board would have the ability to withdraw it, but our position is that the waiver they're stating was not granted. I would also note there is another petition pending before the board for similar relief from the rules.
So one of the things we asked for is that the prorated amount to be refunded in 60 days. How do we make sure that?
Well, they would report back to staff, the list,
Quarterly,
give us
yeah.
a list of the customers that they failed to prorate, and then how much that money was, and then how they were going to refund it. Obviously, it's simple if a person is still a customer. If they're not, but we would talk to the company about that and determine that they were in compliance with that. If they weren't in compliance with that, we'd come back to the board.
Thank you.
We've said many times here that we expect people to get what they pay for. We don't expect them to get more than they should, but we don't expect them to get less than they should. And if I cancel my service at a certain point, that bill should be prorated because I'm not using that service for the rest of that month. It makes sense, and it's something that is fair to the ratepayer. And that's all we're looking for, is fairness across the board. People should get only what they pay for, and nothing less or nothing more. So, any other comments? Roll call.
On the motion to approve staff's recommendation, Commissioner Holden?
Yes.
Commissioner Solomon?
Yes.
Commissioner Chivukula?
Yes.
Commissioner Gordon? President Fiorelisa?
Yes. DAG, you're new too, yes?
Yes, good morning, Mr. President, Commissioners. My name is Malie Harnett-Tovic. I'm the Deputy Attorney General. It's a pleasure to be here, and I really must commend the staff on their knowledge and their warm welcome during this transition.
Welcome to serving us. We
Thank
appreciate
you.
it. Thank you. Nothing under telecommunications. That brings us to water. Ben, you're back.
I am, sir, thank you.
And that DAG to your left does not have to be introduced.
He is not new.
Not new.
Item 5A is another financing petition. This is the petition of Gordon's Corner Water Company for authority to execute up to $2 million of long-term debt obligations. The petitioner has received a commitment from a lender for a senior secured term loan in the amount of up to $2 million. The loan will be for a term of 21 years with a fixed rate of interest to be established at closing. The proceeds will be used to finance the construction of well number 14 and for upgrades to water treatment plant number 1 in Manalapan Township. The terms of the senior secured term loan appear to be reasonable, considering the sources of financing available to this petitioner, its size, financial condition, current markets, and the staff expects that the company will obtain a favorable interest rate at the closing of that term loan. Rate Counsel has reviewed the petition and is not opposed to approval, and the Office of the Economist recommends approval of this matter.
So moved.
Questions? Comments? And this is not to be confused with Commissioner Gordon, right?
Not to my knowledge.
Okay. Okay. Roll call.
On the motion to approve staff's recommendation, Commissioner Holden?
Yes.
Commissioner Solomon?
Yes.
Commissioner Chivukula?
Yes.
Commissioner Gordon? President Fiorelisa?
Yes. Nothing under reliability and security. No items under customer assistance. That brings us down to clean energy. And the first item, 8A, relates to a landfill. So that must be Scott Hunter around somewhere. You want to put your mic on, Mike, or Scott?
Yes, sir.
Thank you. That's for us hard of hearing folk, you know.
I understand. This is in the matter of subsection T, applications submitted by Sincarfa solar developer for the GEMS landfill. On January 17, 2018, Sincarfa submitted an application to the board for a proposed 4.2 megawatt DC project on the GEMS landfill to be certified as being located on a properly closed sanitary landfill pursuant to subsection T. The project is located in Gloucester Township, Camden County, New Jersey. Staff forwarded the application to the DEP, the New Jersey Department of Environmental Protection, and consulted with the DEP on Sincarfa's application. the DEP determined that the 21-acre area of the 130-acre property on which the solar electric power generation facility will be located constitutes a properly closed sanitary landfill pursuant to the Solar Act of 2012. But the project will require the approval of the DEP for any construction activities on the landfill. On the basis of the DEP's determination of the land use classification and the status of the site remediation and the information contained in the application and other relevant factors, staff recommends that the board conditionally certify the applicant's project as being a properly closed sanitary landfill, with the conditions being that the staff recommends the board require for full certification include compliance with all state and federal law, the DEP requirements for construction of solar on a landfill. And since the subsection T application was received prior to October 29, 2018 deadline for 15-year qualification life for SRECs, staff recommends the board require that the project achieve commercial operation prior to the expiration of the SREC registration, which by rule is 2 years from the date of the SREC registration acceptance letter.
Go, Holden.
I was going to say the date. Okay. I'm going to make a motion. I'll move it.
Second? Questions? Comments?
Scott, this is under the old rules, 15 years, is that what it is?
That's right.
15 years of life, yeah.
Yes, the application was submitted in January of 2018, I believe.
18, yeah, thanks.
Anyone else? Roll call.
On the motion to approve staff's recommendation, Commissioner Holden?
Yes.
Commissioner Solomon?
Yes.
Commissioner Chivukula?
Yes.
Commissioner Gordon? President Fiordaliso?
Yes. That brings us to 8B. Ben? We have an energy efficiency incentive.
Item 8B relates to an application for commercial and industrial incentive exceeding $500,000. Digital Realty Trust, LP, submitted an application under the Large Energy Users Program requesting board approval of a financial incentive of $870,781.60 for energy efficiency upgrades for 2 data centers at Digital Realty's Clifton, New Jersey campus. The total cost of these upgrades is $1,350,214. In order to maximize the data center's energy efficiency, Digital Realty's application proposes energy conservation measures that relate to airflow management and computer room air conditioner or CRAC replacement. To improve the facility's airflow, the application proposes installing a cold air aisle containment system. This approach will increase the air delivery efficiency by separating hot and cold airflows and focusing cold air through perforated floor tiles directly into the server equipment. Digital Realty aims to replace their outdated CRACs with new models that include features to enable more efficient cooling by utilizing external air temperature when possible. Annually, the project is anticipated to conserve 3,388,288 kilowatt hours of electricity and reduce peak demand by an anticipated 387 kilowatts. The proposed project has an estimated annual energy cost savings of $298,169 and includes an additional $22,500 in operational and maintenance savings. The payback period here without incentives is 3.93 years, and when factoring in the incentive, the payback period is reduced to 1.22 years. Staff recommends approval of the application for the total estimated incentive amount.
So moved.
Second.
Questions? Comments? Roll call.
On the motion to approve staff's recommendation, Commissioner Holden?
Yes.
Commissioner Solomon?
Yes.
Commissioner Chivukula?
Yes.
Commissioner Gordon? President Fiordaliso?
Yes. Thanks, Ben.
Well,
8C. CC.
Because that's me.
That's you?
This is a request for an extension of time to complete a solar project under the board's solar renewable energy certificate registration program. Petitioner received an initial acceptance in April of 2019, followed by a 6-month extension to October 2019. Since the board's rules do not provide for a second extension, petitioner now seeks a waiver and a further extension. They attribute the delay necessitating the second petition to an unusually long wait for a permit approval from the Federal Aviation Administration because of the month-long federal shutdown in early 2019. The petitioner's project is complete now. They are waiting, as I understand it, for a final approval from the Port Authority. So until they get that, they can't actually turn it on. So they've requested a second extension. Staff has reviewed this, believes that it is consistent with prior extensions that have been granted by the board, and is proposing that the board grant petitioner a 30-day extension until December 23rd. The effective date of the board order, if it was issued today, would be November 23rd, which is why the extension would go through to December 23rd, in case anybody was doing the math. So that's staff's recommendation that the board approve the extension.
So moved.
Questions? Comments? Roll call.
On the motion to approve staff's recommendation, Commissioner Holden?
Yes.
Commissioner Solomon?
Yes.
Commissioner Chivukula?
Yes.
Commissioner Gordon? President Fiordaliso?
Yes. Now, I know you've appeared before us before, but would you like to introduce yourself? I don't know, we gave you the opportunity to introduce yourself.
Sure. Good afternoon, everyone. My name is Emma Yao-Shao. I'm actually in a different section now, but I'm still covering certain solar and audits matters, so I'll still
Okay.
be around for a little bit. And it's been a pleasure working with the staff and the board for approximately 4 years now.
4 years it's been, yeah. So you looking forward to get rid of us?
I wouldn't put it that way. Yes.
That was kind of a loaded question, wasn't it?
Yes.
Yeah. Well, we wish you luck in your new assignment.
Thank you. Appreciate it.
Okay, that brings us to 8D, which was discussed in executive session. James?
Mr. President, Commissioners, this matter is regarding a request by Ocean Wind to replace their design basis turbine with a different turbine. The board's regulations and guidelines permit an applicant to replace or update equipment identified in their proposal with a more technologically advanced equipment, provided that it is equal to or better than the equipment identified in their application, and that there will be no increase in OREC price and no reduction in local content. On October 2nd, 2019, Ocean Wind submitted a petition to the board seeking authorization to replace their design basis turbine with a more technologically advanced turbine. Board staff reviewed the petition and issued 2 sets of clarifying questions to Ocean Wind. Answers to all questions were received and reviewed by staff. In addition, staff requested the New Jersey Department of Environmental Protection to review any potential environmental impacts associated with the proposed change in turbine. Based on the petition, the responses to clarifying questions, and the NJDEP findings, staff finds that the proposed turbine is equal to or better than the turbine identified in the proposal, that there will be no increase in OREC price, and that there will be no decrease in local content. Based on staff's analysis and as discussed in executive session, staff recommends that the board approve Ocean Wind's petition.
So moved.
Questions? Comments? Roll call.
On the motion to approve staff's recommendation, Commissioner Holden?
Yes.
Commissioner Solomon?
Yes.
Commissioner Chivukula?
Yes.
Commissioner Gordon? President Fiordaliso?
Yes. That brings us to 8E, which was also discussed in executive session. Jim?
Yes, sir. This matter is regarding a contract to develop an actionable plan to provide underserved communities access to plug-in electric vehicles. On January 11th, 2018, the BPU applied for a grant from the United States Department of Energy, Office of Energy Efficiency and Renewable Energy to develop an actionable plan to provide underserved communities access to plug-in electric vehicles. On February 27th, 2019, the board accepted the grant award in the amount of $100,000. On September 10th, 2019, a request for responses was issued to 10 New Jersey public research institutions to develop the plan. On October 22nd, 2019, staff received 5 responses. On November 1st, 2019, an evaluation committee of board staff convened to discuss and technically score proposals. Based on the evaluation committee's work, staff recommends that the board award a contract as discussed today in executive session.
So moved.
Questions? Comments? Roll call.
On the motion to approve staff's recommendation, Commissioner Holden?
Yes.
Commissioner Solomon?
Yes.
Commissioner Chivukula?
Yes.
Commissioner Gordon? President Fiordaliso?
Yes. Thank you, Jim. Brings us to 8F regarding SunPower Corporation.
Commissioners, on September 17, 2019, SunPower Corporation, a solar developer, filed a petition with the board seeking a declaratory ruling that the energy generated from a solar facility it proposes to build on the property of the Delaware River Port Authority be considered generated on the customer's side of the meter for the purposes of net metering and SREC creation. On October 28, 2019, PSE&G filed a motion to intervene, assuring that the board's ruling on the petition could have a direct impact on PSE&G's operations and its customers, including an impact on the company's evaluation process for future net metering projects. Given the central role played by the EDCs in the implementation of the board's net metering rules, staff concurs with PSE&G that the board's ruling upon the petition could have a significant impact upon PSE&G and could potentially affect its evaluation of future net metering projects. Staff recommends that the board grant the motion to intervene.
So moved.
Comments?
Yeah, net metering is a benefit for solar generators. Not only just getting the wholesale rates, instead they're getting the retail rates. And when you're getting retail rates and you are using the existing infrastructure in terms of the grid and some of the distribution system, and definitely the PSE&G is being EDC, they have to get involved. I think we need to look at this overall net metering benefit, I think, in the long run.
We are required to by the Clean Energy Act of 2018, or not required to, but the Clean Energy Act of 2018 addresses net metering at 5.8% of retail sales. There are some triggers that occur at that point, so it will be something we have to revisit.
Any other comments, questions? Roll call.
On the motion to approve staff's recommendation, Commissioner Holden?
Yes.
Commissioner Solomon?
Yes.
Commissioner Chivukula?
Yes.
Commissioner Gordon? President Fiordaliso?
Yes. 8G, matter relates to PSE&G, CEF, Energy Efficiency Program. Stacy, you're doing this? Now, you've fallen down there. I was informed we have to take 2 votes on this? Okay.
That is correct. Hello, Commissioners.
Hello.
Richardson. About Direct Energy's motion for reconsideration regarding PSE&G's Clean Energy Future Energy Efficiency Program petition. I will provide the relevant procedural background before addressing Direct Energy's motion. I will also address a request from Sunrun that the board relax or disregard its procedural rules regarding the scope of Sunrun's participation in this matter. The procedural history is, I'm trying to provide the relevant procedural history, but it is rather complex, so thank you in advance for your patience. On October 11th, 2018, PSE&G filed a petition with the board seeking approval to implement its Clean Energy Future Energy Efficiency Program, which included 22 subprograms with a total proposed investment of approximately $2.8 billion over the 6-year term of the program. With a total proposed investment of approximately $2.8 billion over the 6-year term of the program. The company proposed to recover the costs associated with the 2018 EE programs through a new component of the company's Green Programs Recovery Charge. In addition, the company requested board approval of its proposed mechanism to recover lost revenues. The board designated Commissioner Solomon as the presiding commissioner in this matter. A total of 9 entities requested to intervene. One of these was Direct Energy, which moved to intervene on November 16, 2018, on behalf of 5 affiliated third-party suppliers on the grounds that PSE&G's 2018 EE programs, if approved, would enable PSE&G to provide products and services already being offered in the private, unregulated market at a competitive advantage compared to participants in that market due to PSE&G's ability to use ratepayer funds, leverage customer data, and offer on-bill financing. On December 6, 2018, Direct Energy, referring to itself as market participants, filed a supplemental motion to intervene, requesting the addition of Just Energy Group and NRG Energy based on shared interests with Direct Energy in this matter. PSE&G filed letters in opposition to these motions, and Direct Energy submitted reply letters. Direct Energy submitted reply letters. On January 22, 2019, Commissioner Solomon issued the pre-hearing order in this matter. After considering the 9 motions for intervention and 6 motions for participation, Commissioner Solomon granted intervention to the Eastern Environmental Law Center, which represents 5 state and national environmental organizations, and the New Jersey Large Energy Users Coalition, which includes some of the state's largest consumers of energy. Commissioner Solomon denied the remaining motions for intervention, including that of market participants, and instead granted them participant status on the basis that to admit as an intervener each entity that presented the argument that it had a significant interest in the proceeding would tend to produce delay or disruption in the proceeding. Administrative efficiency was a significant factor based on the board's need to fulfill its statutory obligation to act upon the petition within 180 days. On January 29, 2019, the market participants filed a request for interlocutory review of the presiding commissioner's denial of its motion to intervene. PSE&G filed its opposition to the request. We're getting close. In its February 27, 2019 order, the board granted interlocutory review and affirmed the denial. Oh, louder? Or slower? Okay. In its February 27, 2019 order, the board granted interlocutory review and affirmed the denial. The board granted intervention to the Keystone Energy Efficiency Alliance, KEA, a nonprofit tax-exempt 501c6 corporation comprising approximately 50 energy efficiency businesses working in Pennsylvania and New Jersey. The board saw KEA as a trade organization representing multiple companies with similar or identical concerns in this matter, and noted that KEA's members included one of the entities that had joined the market participants' motion to intervene, and 3 businesses that had sought and been granted participant status in the proceeding. On March 8, 2019, the market participants filed a motion for reconsideration and submitted as new evidence an affidavit from KEA that KEA did not intend to represent the interests of the market participants in this proceeding. PSE&G filed its opposition to the motion, and the movements filed their reply. The board now considers the market participants' motion for reconsideration of the board's February 2019 order. Given that the law provides that the board may at any time revoke or modify an order that it has made, and taking into consideration the new information that Kia does not intend to represent the interests of the market participants, and that a board decision on the petition has been extended until March 16th, 2020, staff recommends that the board grant the market participants' motion and reverse its previous decision, based on the findings that the nature and extent of market participants' interest warrants intervenor status, and that their inclusion will add measurably and constructively to the record in this proceeding without raising the prospect of confusion and delay. So that is the first item in the first vote.
So moved.
Comments? Questions? Roll call.
On the motion to approve staff's recommendation to approve Direct Energy's motion, Commissioner Holden?
Yes.
Commissioner Solomon?
Yes.
Commissioner Chivukula?
Yes.
Commissioner Gordon? President Farrellyso?
Yes. Go on, Stace.
Okay. The additional matter for the board's consideration is Sunrun's request of September 13th, 2019, that the board relax its procedural rules regarding the scope of Sunrun's participation in this matter. Sunrun moved for intervention in this proceeding in November 2018 based on its experience and perspective as the largest residential solar and energy storage provider in the country and its operations in PSE&G's service territory. On January 22nd, the presiding commissioner denied Sunrun's motion and granted it participant status based on the finding that Sunrun did not make a showing that its interest warranted granting its motion to intervene, given the need for prompt and expeditious administrative proceedings. On February 7, 2019, Sunrun sought interlocutory review of the presiding commissioner's denial of intervention. PSE&G filed a letter in opposition. In its February 27, 2019 order, the board granted interlocutory review and affirmed the presiding commissioner's denial. On September 13, 2019, Sunrun submitted a letter to the board regarding the joint stipulation of settlement filed by the parties on September 9, 2019. Sunrun asked that, in the interest of fairness and justice and pursuant to the board's administrative procedural rules, the board relax or disregard the procedural rules that form the basis for the rights of participants in this matter to make an oral argument at hearing and file a post-hearing brief. Sunrun requests that the board allow Sunrun to participate in any future settlement discussions and potential final resolutions or additional interim agreements regarding PSE&G's petition. PSE&G filed a letter stating that it did not object to Sunrun's involvement in settlement discussions, provided that several conditions were met. Sunrun did not accept all of PSE&G's proposed conditions. Staff suggests that Sunrun's letter seeking participation in future settlement discussions or interim agreements is untimely, as it arrived many months after the deadline for a motion for reconsideration. That is, the board's administrative procedure rules state that a motion for reconsideration may be filed within 15 days after the effective date of a final decision or order by the board, which was its February 2019 order. Staff therefore recommends that the board deny Sunrun's request and affirm its decision in the February 2019 order as it relates to Sunrun.
So moved.
Questions?
Just one sentence. What are we doing here?
So in the second vote, Sunrun has requested that the board relax its procedural rules and allow it instead of the procedural rules allow participants to file an argument at hearing, to make an argument at hearing and to file a post-hearing brief. Sunrun is requesting that the board relax those rules and allow it to participate in settlement discussions and any additional interim agreements.
Thank you.
Any other questions, comments? Roll call.
On the motion to approve staff's recommendation to deny Sunrun's request, Commissioner Holden?
Yes.
Commissioner Solomon?
Yes.
Commissioner Chivukula?
Yes.
Commissioner Gordon? President Farrellyso?
Yes. Thank you, Stacy.
Thank you.
And that brings us to miscellaneous item A regarding an MOU.
Oh, but I have one question. The one we denied Sunrun, but we have to give another one the intervener status. That was not in the motion. Market participants.
I think we voted on that first.
We already voted on that.
Yeah.
That's what the confusion. Okay, great. Okay. That's, you are so slow. So.
Now, before we start, you're relatively new, Mr. Deputy Attorney General?
Yes, hi, I'm Paul Uchek, also a new Deputy Attorney General. Been here for about 2 months. I mainly work on federal energy regulatory issues, litigate in water issues, and so forth.
Good. Well, welcome.
Thank you.
That should keep you busy.
Yeah, it should. Before we go on, is there any other new Deputy Attorney General here? That we have? That's it? Okay. I want to make sure everybody gets introduced so they can bust you. No, I'm not. We should. We will. Mr. Walker.
No.
Now it is.
Thank you. Good morning, Mr. President. Good morning, Commissioners. How are you today?
Good.
Item 9A, we're bringing before the board to essentially establish protocols and funding and specific projects for the use of State Facilities Initiative funding. This funding is allocated yearly through the Clean Energy Group on their annual budget. And along with this order, we're asking the board to approve and authorize an MOU between us and DPMC, the Department of Project Management and Construction. We work hand in hand, the State Energy Office, with DPMC to perform upgrades, efficiency projects on state facilities proper. These include things like correctional facilities, veterans facilities, office buildings. Hughes Justice Complex is and NJDEP headquarters is an example of these type of projects. For several years, the SFI funds have been granted to the SEO's use within the Energy Capital Committee and DPMC, and we've accumulated approximately $37.8 million to date, of which $2.24 million has been spent and a significant amount has already been allocated. The idea of this MOU was to establish how the two agencies would work together to establish a project list going forward and to honestly bring transparency to the board. Because as it's been done, it's just, it's been internal communications, departmental agreements on these projects. We want to let the board know what we're doing, get the board's authorization for our intended use of all these funds, and also allow the board to enable the State Energy Office to supplement projects on the list or off the list depending on public policy or emergent needs. So the key points will be that DPMC will have the construction and management role. They will be responsible for all the contractors. BPU's role is we will be in charge of the SFI funds. We will distribute those in the Energy Capital Committee, of which we are a member. We will have control over what projects will be done and what not projects not to be done. The MOU also is being utilized to capture the funds, to basically to honestly say, this is what we have, this is what we're going to use it for, to identify it, and again, the ability to modify. Specifically in this order, we're presenting the MOU to the board. We're asking that the board let the State Energy Office be in control of that, be allowed to modify budgets or adjust budgets as necessary, adjust projects as necessary, as I said, depending on emergent needs. What we're also indicating is that we don't want to run rampant either, so if there's a new project that comes on board or if there's an increase in costs, 1 million or above, we will come before the board. And we're also asking the board to let us initiate a protocol that annually, every May, before the budget is finalized in June, we will come to you, let you know how we've done on this list, what changes we've made to this list, and ask permission to go forward. So with all that said, we're asking that the board determine that the continued working relationship between the SEO and DPMC is vital and essential. We're asking that the board find that the designated project lists attached to the MOU is reasonable and appropriate. We're asking the board to agree that the procedures between DPMC and BPU described in the MOU are appropriate. We're asking the board to approve the MOU and to authorize President Fiordalisa to execute it on behalf of the board. And then finally, we're asking the board to direct us to take the appropriate measures to implement the MOU and also to come before you every May with how the projects are going.
So moved. Second.
Questions? Yes.
Yeah, thank you, first of all, for putting this together and putting it into a form that is going to be reviewed by this board. I know, over the years, on occasion, I've had you come in with questions regarding different projects, and I think this will be a much more streamlined form for us all to know about the projects that are being undertaken with these funds. And it certainly is an impressive list of projects, and look forward to the work that you're going to be doing. Thank you.
Good.
One of the, Tom, I didn't mention to you, did not, that when you're doing these projects, keep the energy master plan goals also in, because a lot of them overlap with the Clean Energy Act, energy efficiency program, so you want to make sure.
Yes, sir. We're doing that on the recently identified projects, and we're going back on the previously identified projects to make sure we're keeping up with policy.
Any other comments? Questions? Roll call.
On the motion to approve staff's recommendation, Commissioner Holden?
Yes.
Commissioner Solomon?
Yes.
Commissioner Chivukula?
Yes.
Commissioner Gordon? President Fiordalisa?
Yes. That brings us to miscellaneous item B. I am recused from that, so I'm going to ask Commissioner Chivukula to take over the meeting. Commissioner?
Thank you, President. This matter before us, this is known as the Page Grant, and the staff will be making a recommendation. And should I just make the motion?
No.
Okay. All right. Based on the staff's recommendation in the executive session, I would like to make a motion to divide the. That's why I asked the question. Okay. That's why I asked the question.
The board as was discussed in the executive session.
So moved.
Basically, let me clarify the motion, so that way. Yeah, because the motion is to divide the award.
No.
No?
No.
No?
Commissioner, I think the way it's supposed to work is because it was done in executive session, you don't go into the specifics of the vote, just the board will address the motion.
Shame on me.
The motion was to award it
As recommended, okay. Apologize, yeah. She got the motion, I second it, yeah.
Right.
Okay. I second it. Commissioner Holden made the motion for staff recommendation. I seconded it, and now we do a roll call. Roll call.
Excuse me, won't you just, could you go back and read the recommendation? Yes.
Let him restate it.
Staff recommends that the board approve the contract award as discussed in the executive session.
And for the record, that is the only pending recommendation.
Yes.
Okay. Now we have to call roll call. Any discussion?
Like we discussed it, we can't go into any detail. I'm just following Robert's rules on that.
Staff, if I may clarify, so the commissioners need to vote upon staff recommendations as discussed in executive session without disclosing anything that was discussed in executive session.
It's a vote.
Yeah. You make it.
On the motion to approve staff's recommendation pursuant to the discussion in executive session, Commissioner Holden?
Yes.
Commissioner Solomon?
No. I do not agree with the recommendation.
Commissioner Chivukula?
Yes.
Commissioner Gordon?
No.
Okay. I guess the motion.
So noted.
So we have, so moved. Okay. Let's go back.
If there are no other items, thank you.
Mr. President, I did miss one of our new DAGs, and I would be remiss to leave him out, Matko Illick. If you
Okay.
Stand up. I think you've seen them all now.
Thank you very much. It is a pleasure to work alongside you. Just like with my colleague, DAG Paul Uchek, I've also been working for 2 months with the AG's office.
You're welcome.
Thank you very much.
One thing I do object to, Dave, is that they're all much too young.
I concur.
Okay. Well, thank you. If there are no other items before the board, I will entertain a motion to adjourn.
Second.
All those in favor? We're adjourned.